Hello, and welcome to this lecture on the use of force in international law. We are going to start addressing the rules that govern the legality of the use of force. That is, when is it legal for states to resort to armed force? While the rules are relatively clear and easy to understand on paper, we will see that's not that clear in practice, and when a state uses force, normally the actions are the object of great controversy. In this specific lecture and others to follow on the use of armed force, we will illustrate explanations as always with specific cases. Some of them have been adjudicated by the International Court of Justice, like the oil platform case between the United States and Iran, or Democratic Republic of Congo and Uganda. However, probably more relevant are for understanding the legal challenges that are raised by the use of armed force are other scenarios that have not reached the International Court of Justice, but that have been discussed at length by commentators. Among the examples featured in this presentation and others, we will address, for instance, the poisoning of former Russian agents Litvinenko and Skripal in the UK, several airstrikes in Libya, Iraq, or Syria, targeted killings in Pakistan, Yemen, or Somalia, as well as the questionable operations against non-state actors in the territory of third states. There's lots to cover, so let's start. This video will just introduce the main rules governing the use of armed force and its exceptions. It will detail the scope of the prohibition contained in Article 2.4 of the United Nations Charter and expand on the meaning of use of force in general. So we are going to focus on what use of force means, how it is different from armed attack or even the crime of aggression. Other recordings to follow will address the most uncontroversial exceptions to the prohibition of the use of force, which are self-defense and the use of force authorized by the United Nations Security Council. And then we will address more controversial scenarios, such as humanitarian intervention, self-determination, rescue of nationals, and finally, the use of force by invitation. So, the basic rules. The use of force is prohibited in international law since 1945, as clearly established in the United Nations Charter, and by now totally accepted as customary law that states do not contest. There are many relevant historic precedents that led to this prohibition, but we will not explore them here. For the purpose of this explanation, it suffices to say that after the Second World War, the idea that prohibiting any use of armed force was necessary to prevent the Third World War became consolidated, and there was enough consensus to consider it a fundamental principle in international relations. In addition, the states founders of the United Nations, the main organization that's actually called to prevent a Third World War, supported the need of linking the prohibition of the use of armed force to the promotion and protection of human rights, as well as the need for development. So these three foundational principles, human rights, prohibition of the use of force, and development, were codified as what we call the pillars of the United Nations organization. The prohibition of the use of force is contained in Article 2.4 of the United Nations Charter, and the right to self-defense as an exception to the prohibition is codified in its Article 51. In addition, the regime established in Chapter 7 of the United Nations Charter, providing the basis for a system of collective security that was meant to operate under the auspices of the Security Council, was never implemented as intended, and we will say more about this apart from what we have already said in the video on enforcement of international law, the Security Council, and sanctions. Okay, so as I said, we will C, exceptions that are not contested, self-defense and collective security, and then other exceptions to the use of armed force that have been tested in state practice and through different theoretical frameworks have not found general support. So we will look into this after, and mainly the case of humanitarian intervention and its cousin, the responsibility to protect doctrine. We also said something about this when we saw the Security Council, the exercise of self-determination involving the use of force, and the rescue of nationals. Finally, a special category that some will fit as one of the exceptions and others as outside the scope of the prohibition on the use of force, as outlined in Article 2.4 of the Charter, is the use of force by invitation. So let's see each of them with a bit of more detail, using, as always, cases to help understand the legal issues underpinning them. In addition to its articulation in Article 2.4 of the United Nations Charter, the prohibition of the use of force is also considered a written expression of a well-established customary rule. There is a strong consensus of, or what we have called opinio juris when addressing the topic of customary law, about the rule prohibiting the use of armed force. Several UN General Assembly resolutions are considered particularly relevant as written expression of the content and the scope of the customary rule banning the use of armed force. In addition, the International Court of Justice has also contributed to the acknowledgement of the rule as customary law in several cases, including the 1949 Corfu Channel case between Albania and the United Kingdom, the 1986 military and paramilitary activities in and against Nicaragua between Nicaragua and the United States in 1986, the 2003 oil platform case between Iran and the United States, the advisory opinion on the construction of a wall in the occupied territories that was delivered in 2004, as well as the 2005 case between the Democratic Republic of Congo and Uganda concerning the armed activities on the territory of the Congo. As we will see, however, the consensus on the existence of the rule is undermined in practice by how the exceptions to the prohibition have been interpreted by states when they have been determined to use armed force. In other words, while states do not contest the prohibition, many or a few that have used force will make an interpretation of the exceptions that will justify the use of armed force when it is their chosen course of action. Before we continue with those exceptions, let's clarify a bit more the scope of the prohibition. I reproduce again Article 2.4 of the United Nations Charter, establishing the general prohibition of the use of armed force. As stated in my earlier video, the expression use of force is understood as the use of military armed force, although in practice what military or armed force means is also not straightforward, and the typical example are certain cyber attacks. In the letter of Article 2.4, both the use of force and the threat to use force are prohibited. There are other points regarding the scope of the prohibition that I want to address. First of all, I have highlighted it there in yellow. The language used in Article 2.4 seems to indicate restriction to the prohibition as if limited to uses of force with a specific intent. That is, those that are against the territorial integrity or political independence of another state, or in any other manner inconsistent with the purposes of the United Nations. However, this sentence has been interpreted as strengthening rather than restricting the scope of the prohibition of the use of force. As the travaux préparatoires of the United Nations Charter reveal, I want to explain this a bit. The travaux préparatoires are the papers reflecting the negotiations that led to the adoption of the United Nations Charter. So according to what we know about these negotiations and what's documented there, the travaux préparatoires, the intention of states drafting the article was to strengthen the definition and the expression any other manner inconsistent with the purpose of the United Nations was included to avoid gaps that would lead to a different interpretation of the prohibition. In summary, independently of the motive, every use of force is prohibited because the use of force will always constitute a breach of the territorial integrity and independence of another state. A second issue in relation to the scope of the prohibition relates to whether there is a minimum threshold of seriousness for a use of force to fall within Article 2.4. Is there any threat or use of military force that is not prohibited? Do you need a certain level of seriousness or the gravity of the attack for it to fall within the prohibition? Article 2.4 that we have reproduced now several times uses the expression use of force. However, Article 51 that acknowledges the exception to the prohibition of self-defense uses a different language and speaks about armed attack. So this complicates matter further. Are these two terminologies the same, use of force and armed attack? Let's try to clarify this. I am going to use several examples of isolated uses of lethal force targeting a specific individual in the territory of another state to show the kind of problems raised. So I'm going to use examples where arguably the threshold could perhaps not be reached because they relate to very isolated examples where the target objective was a single individual. So for instance, on 4th March 2018, Mr. Sergei Skripal, his daughter and other individuals were exposed to the nerve agent Novichok. I have here reproduced a photo of Mr. Skripal and his daughter. He was a former Russian agent who had been convicted of espionage for the West by the Russians. So the Skripals, the father and the daughter, actually finally recovered from the poisoning, but Don Sturges, a British citizen incidentally exposed to the poison, died from it. A few days later, on 12 March 2018, the UK Prime Minister at the time, Theresa May, demanded an explanation within 24 hours. Otherwise, she warned, the UK will conclude that the actions were attributable to Russia and constituted an unlawful use of force by the Russian state against the United Kingdom. So Theresa May categorized the attempt to kill the Skripals as a use of armed force. However, the death of Mr. Litvinenko in 2006, quite a few years earlier, another former Russian agent in the UK soil who was presumably also poisoned by Russia, was not categorized as a use of armed force by the British government. It was instead labeled as a much more generic and acceptable breach of international law. Another case of killing outside the territory of a state corresponds to a widely reported case, Mr. Khashoggi, who on the 2nd of October 2018 entered the Saudi consulate located in Istanbul, Turkey. Mr. Khashoggi was a national from Saudi Arabia, and he was well-known journalist and dissident. The purpose of his visit to the consulate that day, and that was made by appointment, was to obtain the necessary papers to become married to his fiancée, who was actually waiting outside the consulate. Mr. Khashoggi was tortured and murdered, and his body dismembered and destroyed. A United Nations expert, the Special Rapporteur on Summary Extrajudicial or Arbitrary Executions, Agnes Kalamard, carried out an investigation on the case and concluded that the murder of Khashoggi amounted to an illegal extraterritorial use of armed force in times of peace. In her 2019 report, she also referred to a UN Security Council resolution that was adopted in 1988, where the killing of an affiliate to the Palestine Liberation Organization, Khalil al-Wazir, that was killed by Israeli forces in Tunisia, was characterized by the Security Council, as you can see in the extract I have reproduced here, as an use of armed force. However, other states that reacted to the killing of Khashoggi deplored the violations of international law involved, but were much more reticent to specify what violations specifically were involved. Other cases of use of lethal forces to target specific individuals, such as some of the killings that have been targeted with autonomous weapons in Yemen, Somalia, or Pakistan, have not been expressly characterized by other states as illegal uses of, or legal, as they have not been characterized as uses of armed force. Similarly, the killing of the Dutch photographer involved in the Rainbow Warrior case that we have also touched upon when we look at responsibility of a state, was not treated as an illegal use of armed force. In conclusion, there is no uniform criteria or practice that is very useful as a guideline to establish whether a minimum threshold is necessary to decide what constitutes an illegal use of force. Low levels of lethal force have deserved different reactions depending on a range of geopolitical factors. In purely legal terms, all uses of lethal force affecting another country are prohibited, unless they fit an exception. For instance, self-defense, or as we will see, if a state consents to targeted killings within its territory, or this could preclude the illegality of the use of force. At a practical level, the main purpose of categorizing a low-level use of lethal force as use of force under international law or not, beyond the academic debate, is important because it helps decide if the reaction to that low level of use of force is legal itself. So, for instance, if a state is claiming to act in self-defense in the use of armed force, it needs to meet the requirements of proportionality, as we will see. And in this scenario, very low levels of uses of force will probably don't deserve a reaction in self-defense using also armed force. That will be almost never proportional. As others have argued too, if the use of force against non-state actors involves damage in a third state that is not linked to the non-state actor, it seems also unreasonable to decide that any use of force by these non-state actors will be enough to react in self-defense. But we'll see a bit more about this later when I touch on self-defense against non-state actors, on the use of force in self-defense against non-state actors. These considerations bring us back to the different language used in Article 2.4, establishing the general prohibition of the use of force, and that uses the expression use of force, compared to Article 51 of the Charter that recognizes the right to self-defense, but uses the expression armed attack. These two expressions could be interpreted as synonyms, but in practice and in the case law of the International Court of Justice, the legal use of self-defense in response to the so-called armed attack seems to require a minimum threshold of intensity. Both in the case concerning the military and paramilitary activities in and against Nicaragua between the United States and Nicaragua, as well as in the oil platform case between Iran and the United States, the International Court of Justice has distinguished armed attacks requiring the most grave forms of the use of force from less grave forms of the use of force. In summary, state practice indicates that small-scale border attacks or other low-level uses of force involving the use of lethal force are not excluded from the concept of use of force or indeed the terminology armed attack. Any level of use of force may give rise to the right to self-defense. However, because the state invoking self-defense must use force respecting the proportionality principle that requires that any use of force in self-defense is proportional to the aim of repelling the attack, it is likely to require to be the response to an ongoing armed attack that reaches a certain level of intensity. So far we have been trying to establish the scope of the prohibition on the use of force. We have seen that the use of force that's prohibited is the use of armed force, that there's no need for a minimum threshold, but that there is a different terminology, use of force and armed attack, that has practical consequences and has been considered as such in the International Court of Justice. And third, also concerning terminology that is relevant to determine the scope of the prohibition on the use of armed force is this other word, aggression. So states and commentators may refer to the illegal use of armed force as an act of aggression. The word aggression is important, appears in Article 1 of the United Nations Charter, where the purposes of the United Nations are laid down. So specifically, Article 1 says that the suppression of acts of aggressions is one of the purposes of the organization as a means to maintain international peace and security. And then Chapter 7 of the Charter is entitled Actions with respect to threats to peace, breaches of the peace, and acts of aggression. And the chapter itself opens with Article 39, where it is established that the United Nations Security Council is trusted with determining the existence of a threat to the peace, a breach of the peace, or an act of aggression. In other words, an act of aggression is what triggers the action of the Security Council according to Chapter 7. However, the Charter does not define what is aggression. This was done by a General Assembly resolution in 1979, where aggression is defined, and I have reproduced it here, as the use of armed force by a state against the sovereignty, territorial integrity, or political independence of another state, or in any other manner inconsistent with the Charter of the United Nations. And then Article 3 provides a list of possible examples of acts that will constitute aggression. For many years, this was the only provision at universal level defining aggression in an international instrument, but as a General Assembly declaration without binding value per se. In the context of the International Criminal Court Review Conference that was held in Kampala in Uganda in 2010, it was agreed to amend the International Criminal Court statute, that is, the treaty creating that tribunal, so it could exercise jurisdiction over the crime of aggression. For that purpose, the amendment also included a definition of the crime that is only legally relevant within the confines of the court in prosecuting individuals for the commission of international crimes that fall under its jurisdiction. So while this is confined to the competencies of the International Criminal Court, it is highly symbolic of the consensus reached among states of what is considered aggression. And I have reproduced the definition here. The International Court of Justice has never categorized a particular use of armed force as aggression. However, its case law that, as have said, prefers some distinction in the seriousness of the prohibition of the use of force seems to have found some acceptance, as it can be deduced from the definition finally adopted in 2010 and reproduced here. States seem to actually support this approach of the International Court of Justice, grading the seriousness of violations of the prohibition of the use of force. So while any use of lethal force can be considered illegal unless fitting an exception, a breach of the prohibition of the use of force will only amount to aggression when it reaches certain gravity and scale. A final question is whether it matters that the action that constitutes armed force, armed attack, or aggression comes from a state or a non-state actor, especially when a state claims a right to self-defense in retaliation to a use of force that can be attributed to a non-state actor. Again, we will get back to this question again in the next video, covering the exceptions of the rule and in particular self-defense and the authorization of the Security Council.